All right, so today we're going to talk about concurrent ownership of real property. And it is fundamental to your understanding of how real estate can be owned by multiple individuals at the same time. Okay. And we're going to look at the various forms of concurrent ownership and their unique characteristics and the legal implications that arise from each one of them. And this is a topic that will regularly appear in practice. So, kind of understanding this, it'll serve you well. So let's start with the absolute basics, and that is the definition of concurrent ownership. And concurrent ownership simply means that two or more owners hold an interest in real property. And that's in contrast to owning the property in severalty, which means that a single owner holds the entire interest in the property. So think of it like this: if you own a house entirely by yourself, you own it in severalty. But if you buy that house with your spouse or, say, with a business partner, then you're engaging in concurrent ownership. Okay. Now, it's crucial to understand that not all types of concurrent ownership are recognized in every state. So each state is going to have its own specific laws governing those property rights. But here in Georgia, our focus is going to be primarily on two recognized forms, which is tenants in common and joint tenants with the right of survivorship. Now, we'll also talk a little bit about the tenancy by its entirety. And that's not a form that's recognized in Georgia, but it is important for your more broad legal understanding, especially if you deal in multi-state property issues. Now, let's kind of dig in first on this tenants in common because it is the most widespread form of concurrent ownership, and it is explicitly favored by state law. And this preference stems from its flexibility, particularly regarding like inheritance and transfer. Okay. So, what does it mean to own property as tenants in common? This is where each owner is going to hold title to an undivided interest in the real property. Okay. And the concept of the undivided interest is absolutely critical here. It means that while you may own a certain percentage of the property, say 50%, 30%, 20%, you do not own a specific physically defined portion of the land. Instead, you own a share of the entire property, okay? And each co-owner is entitled to full ownership and possession of the entire parcel, okay? So let's say you have three siblings, right? And they all decide to purchase a cabin in North Georgia mountains as tenants in common. You have one sibling who contributes 50% of the purchase price, one who contributes 30, and one who contributes 20. In a tenancy in common, they may hold unequal or even equal shares. So the first one has the 50% undivided interest, right? The next one has the 30% undivided interest, and the last one has the 20% undivided interest. So that means that while, sibling A put in more money, she can't come along and claim like, I own the front half of the cabin, right? You can't prevent the other two from using any part of it. They all have a right to possess and use the entire cabin, okay? Now, one of the most significant features of tenancy in common, and the reason that it's favored by the law, is that it gives the co-owner the ability to designate upon death where their interest should go. And that is a key differentiator from other forms of ownership. So let's say that second sibling who has that 30% interest passes away, then his 30% doesn't automatically go to the other two siblings. Instead, that it allows that sibling the ability to specify in their will that their 30% should pass, say, to their daughter or their son or their spouse, whoever. And the other two would then become tenants in common with whoever has inherited that land. Again, each still holding their respective undivided interest, okay? And that flexibility in inheritance is a major advantage when it comes to estate planning, all right? Now, any conveyance from a single owner conveys only their share. Okay, so that means if you have the one who has, say, the 20% undivided interest, that person can do they can transfer it without having the consent of the other two siblings, right? They cannot sell the whole entire cabin. They can just sell their 20% interest in it. Okay. And the buyer would then step into that sibling's shoes, become a tenant in common with the other two siblings, and would only hold the 20% undivided interest. Okay. Period. Now, the ease of transfer, again, while offering flexibility, it can sometimes lead to situations where many individuals own like these small fractional interests in a single property. And that can turn around and complicate the management of it. All right. So what happens if the co-owners disagree on the management or the sale of the property? Or what if one co-owner, wants to take out their financial interest? In those cases, you would have to ask for a partition and get the court to order it. All right. And a partition is a legal process that is going to physically divide the property among the co-owners if it's feasible, or more commonly, it will force the sale of the property and then it will distribute the proceeds according to the co-owners, pro rata share or their proportionate share. Okay. So let's say that the sibling who owns the 50% wants to sell the cabin, but the other two refuse. Then that sibling can file a lawsuit for a partition. And in that case, the court would then have to decide the most equitable way to resolve that particular dispute. Now let's look at the second form that is recognized in Georgia, and that's the joint tenants with the right to survivorship. And it's important in this form of ownership, particularly those who want the automatic transfer of their property upon their death. Okay. Now, joint tenancy with the right to survivorship is available to both married and unmarried. Now, the defining feature here is the right of survivorship. And that means that upon death of a joint tenant, their interest in the property is going to automatically pass to the other joint tenant. All right. And that's in direct contrast to the tenants in common. And I have to say, this right cannot be overridden by a will. Okay. So let's say that you have a married couple and they purchase their primary residence with joint tenants with the right of survivorship. So if the husband passes, his half of the interest in the home is going to automatically and immediately transfer to the spouse. All right. And the spouse now owns 100% of the property. This happens by operation of law, not through a will. Okay. So even if he had a will that stated that his interest in the house would go to his children from a previous marriage, then the right of survivorship is still going to trump that will. Okay. And the spouse is going to receive the entire property. And that avoids the probate process for this particular asset, which does provide a significant advantage when you're talking about estate planning. Now, while the right of survivorship is key at death, during the lifetime, the joint tenants with the right to survivorship are free to transfer their ownership just like tenants in common can. However, there is a huge consequence for this, and that is that upon the transfer, the joint tenant with the right to survivorship interest is going to be converted to a tenancy in common interest. And that's with regard to the other joint tenants with the right to survivorship. And this is known as severance. Okay. So let's say that you have the couple who are joint tenants with the right to survivorship, right? So let's say that the husband decides to sell his 50% interest to his friend. And in that particular case, the joint tenancy between the spouses is severed. And now the friend and the spouse would now own the property as tenants in common. That means that if the friend later dies, his interest would not automatically go to the spouse. It would then pass to that person's will or their intestate, if they were intestate, through the state's laws regarding people who die intestate. Now, if the spouse later dies, then her original joint tenant with the right to survivorship interest would pass to her heirs, his or her heirs, and not to the friend, okay? Because it's now treated as a tenancy in common. So the right to survivorship between the spouses is broken once the husband conveys his interest, okay? Now, like tenants in common, the partition may be achieved through a court order for the joint tenants with that right of survivorship. So if you have the spouses who have a falling out and they can't agree on selling the house, either could petition the court for a partition. And the act of the partition, again, is it's going to sever that joint tenancy, and it's going to convert it into a tenancy in common for the purposes of the division or for the sale. Now, the creation of a valid joint tenancy with the right to survivorship is very strict, and it requires the presence of what are known as the four unities, okay? And these are often remembered as the acronym PITT, okay? So the P is the unity of possession. And that unity means that all co-owners have an undivided interest in the whole of the property, all right? And that's the same with the tenants in common. So each joint tenant has the right to possess and use the entire property and not just a portion of it. Now, the I is the unity of interest. And this is where all co-owners must own equal shares. So this is a major difference from the tenancy in common. So if there are two joint tenants, they must each own 50%. If there are three, they own 33.33 and so on, okay? Now, if the ownership percentages are unequal, it cannot be a joint tenant with the right to survivorship. Now, the first T is the unity of time. And this is where all co-owners must take title at the same time. That means that they acquire their ownership interest simultaneously through the same exact transaction. Okay. So, for example, if a deed conveys property to, a couple with as joint tenants with the right of survivorship on the same day, then that unity is met. Okay. But let's say that you have somebody who owns property previously and then deeds it to themselves and, their spouse as joint tenants. Then that unity is often not met directly because it's requiring a straw man transaction where, the person who owns it is now deeding it to a third party who then deeds it back to the two of them, making sure that they take title at the same time. Now, the last one is the unity of title. And this is where all co-owners have to take title in the same instrument. And that means that they are named on the same deed or document that is going to transfer ownership. So if they receive their interest through separate deeds, even if it's signed on the same day, it would defeat that unity, okay? Now, the absence of any one of those four unities will prevent the creation of a valid joint tenancy with the right to survivorship. And the ownership then would typically default to the tenancy in common. And that's why it's that's why a careful drafting of deeds and attention to detail are going to be paramount when creating or analyzing whether or not a joint tenancy exists. So now let's talk about a form of concurrent ownership that is not recognized in Georgia, and that is the tenancy by the entirety. And while it's not applicable here, it is vital for kind of your general understanding of property law, especially if you practice in states where it is recognized, okay? So tenancy by the entirety is similar to the joint tenancy with the right to survivorship in that it includes the right to survivorship. However, I have to say there are some distinct features that we have to talk about. First is the marital requirement. So the tenancy by the entirety must be between spouses, okay? This is a form of concurrent ownership that is exclusively for married couples, and it reinforces the legal fiction that a married couple is a single entity, okay? It also has indestructibility. So unlike the joint tenancy with the right of survivorship, where one joint tenant can, unilaterally sever the tenancy, spouses in a tenancy by the entirety may not sever or encumber their interest during their, lifetime without the mutual consent of the other spouse. That means that one spouse, they cannot sell their half, They cannot mortgage their half, and they cannot do anything that is going to unilaterally break the tenancy. All right. And this provides a very high level of protection for, marital assets. Now, you have creditor protection. A creditor can only force the sale of property held in the tenancy by the entirety if both tenants by the entirety are liable for the debt. Okay, so that's going to give some significant protection against individual debts of one spouse. So, for example, if only one spouse has a large personal judgment against them, the judgment generally cannot force the sale of the property held in tenancy by the entirety. All right. Now we also have the divorce conversion. So if spouses who hold property by as tenancy by the entirety, they divorce, right? Then their status is going to convert to tenants in common. And the legal entity of the married couple is going to dissolve. And with it, all the extra special protections of the tenancy by the entirety will as well. And then you have partition restrictions. So most states do not permit the partition of property that is held by tenancy by the entirety. Again, it's emphasizing that unified nature of ownership by the marital unit. Now let's talk about marital, separate, and community property, particularly in the context of divorce or annulment. And this area directly impacts how property is divided when a marriage ends. So if a divorce or an annulment occurs, then property has to be divided, right? And Georgia is a marital property state, which is an equitable distribution state. This means that all assets acquired during the marriage have to be divided in a fair and equitable way. Okay? Now, here's a little caveat though, because equitable does not necessarily mean equal. It means that a court is going to consider various factors to determine a fair division. It can mean looking at the length of the marriage, like the contributions of each spouse, that's financial and non-financial, the earning capacity of each, and like their respective needs. So for example, if one spouse was the primary breadwinner and the other was a stay-at-home parent, an equitable distribution might mean that the stay-at-home parent gets a larger share of the assets to ensure their financial stability post-divorce. Now, in the alternative, there are a handful of states that are community property states. I think there's like 9 of them. Might even be less than that. But in those states, marital property is generally divided 50-50. And that means assets acquired during the marriage are presumed to be equally owned by both spouses, and they're subject to an even split upon divorce. Now, California is probably the most widely known community property state, but there are others. I can't remember what they are right off the top of my head, but regardless of the state, let's talk about separate property. This is generally not divided in a divorce, and separate property typically includes assets that are owned by a spouse before the marriage, gifts that are received by an individual spouse during the marriage, and then inheritances that are received during the marriage. Okay. But there is a very significant nuance here. So items that are purchased with separate funds for the benefit of the marriage can be deemed as marital property, and it might convert, also the separate property to marital, and that's known as transmutation. So, for example, if one spouse uses an inheritance, which is separate property, to make, say, a substantial down payment on the marital home, and both spouses contribute to the mortgage and the upkeep over the years, then a court might find that the separate funds have been transmuted into marital property, and it's now subject to distribution according to the state. Okay? In the same way, if separate funds are commingled in a joint bank account that's used for a marital expense, then they can also lose their separate character. And that's pretty much it. I just forgot to conclude it on the other slide, so I had to make this one. But let me know if you have any questions. Bye.